gather you may have had a problem with the live feed this morning.
It used to be, my lady.
It's resolved by the sounds of it. Anyway, apologies to anybody who was watching and was affected by the problem.
Thank you, my lady. Professor, before the lunch break, we were talking about using messaging to influence behaviour. In a world of social media disinformation and people simply not engaging with mainstream media, with the news, how do you get the message out to those people who are perhaps less likely to comply in the first place with that guidance?
And that's a really important question, I think. And again, I would want to go back to this core issue of social relationships and trust. You see, when people deal with misinformation, the obvious starting point is to ask about the nature of the information. But imagine a situation where, and that actually it's a situation that happened to all of us, okay? That you are sitting there, you're being asked to take a vaccine, to inject a vaccine into your body. And some people are saying to you, this is really important. This will keep you safe. This will keep your community safe. It's a personal and a social responsibility to do it. And others are saying to you, don't trust them. They are not concerned with your well-being. They are trying to control you. This vaccine hasn't been properly tested. It hasn't been properly developed. It's dangerous, right? Now, we're not vaccinologists. So in the end, you've got to ask, who do I trust? Who do I think is on my side? Who is giving me this information to help me? Who is giving me this information in order to control me? So when it comes to that issue of information, and it's not just about disinformation, the question is, why do we believe any information we're given? It's not the information itself, it's our social relationship to the source of that information that is often absolutely critical, and that's why trust is absolutely at the core of how you respond.
But so how does that work in practice in terms of Scottish government? And when the First Minister, for instance, stands up to describe what's happening, how do you use that to get
I think it has to be in the context of that wider policy of engagement. So if, there you are, you're going for vaccination, and somebody says to you, and you ask a question, what effect will this have on me if I'm pregnant? What is the impact on sickle cell disease? These were questions to which non-experts wouldn't know the answer. Do you, on the one hand, treat that person as dishonourable, as a fool, label them as vaccine hesitant, or do you say to them, really good questions, right? Really good questions, we'll talk to you, we'll listen to you, we'll engage with you. So whatever that Scottish minister says, it will work better in a context where you are building trust, you are showing respect, you're engaging with people, and you're taking their concerns seriously, rather than just dismissing them as fools who are victims of disinformation.
But to what extent does the existence of those issues, in terms of people who don't want to engage, affect the decision-making, the principles behind the decisions that are being made in government to say, we need to do this, we need to do that, and give advice and building up that trust relationship? To what extent is, in your view, were Scottish government aware of the impact of that sort of issue on the efficacy of their decisions?
Well, as I've said to you many times, I'm an academic who sat in the advisory group. I don't sit in the corridors of power. I don't chat to ministers. I don't know. I genuinely don't know what was going on. In our advice, we said to them, the key issue here, as everywhere else, is to do things in an overall context of everything you do, of showing, of building trust. Now, one way you could build trust, for instance, would be for ministers to acknowledge the fact that this is complex and this is difficult, and people are right to have questions. And then to build in processes where people can ask those questions. And also the types of initiatives I spoke about that happened in Israel, not just in Israel, they happened in the UK as well, actually working with black health workers to build those structures of engagement. And the final point is, in many ways, actually you do far better not if a minister gets up, but if a respected member of a community gets up. If an imam, for instance, says to you, it is perfectly legitimate to take a vaccine, at particular times of year and so on. Work through communities. And the way you pose the question, what does a Scottish minister do, in a sense presupposes it's the Scottish ministers to do it themselves rather than to engage and facilitate communities doing things for themselves.
You talk about the need to build trust, but in your statement you also, of course, it's in terms of compliance, there are two sides to it, isn't there? There's building the trust, but then people being able to actually comply with the guidance or the rules and things happening. So
let me start off with the word compliance, because the problem with compliance is it's a very top-down term. You will comply with what I do, right? Whereas actually it has to be much more of a dialogue.
Well, let's take it in stages, because I need to take this quite shortly, and I don't.
I understand.
I apologise for the timing, but I do need to just sort of take it in stages. You have you mentioned in your statement about the need for support quite regularly throughout the statement, and I won't take you to all the references, but I'll take you to one in a moment. But it's right, isn't it, that the reality is, irrespective of the communications and the trust that can be built up, there will always be people who simply, as you say in your statement, as a result of the lack of support, are just not able to comply, or not able, whether the word comply is or adhere, and that cuts then into the way decision making is undertaken. Because, for instance, if you don't have sufficient funding, support, money in the bank, as it were, and you know that if you get a test and you test positive, you have to self-isolate so you can't go to work, you might be less likely to take the test in the first place. If, because you are unable to, you don't have the money in the bank to buy your groceries at the end of the week, you might not be able to go into lockdown because you're with a positive test, with self-isolation, with a positive test, because you will say you can't afford. Now, in terms of the legality, the use of laws, in your statement you say that laws have, the imposition of legislation is actually quite helpful in a lot of regards. But the simple point, or the simple question I want to ask is, in circumstances where you say at paragraph 125 of your statement that the Scottish Government did little to heed the continuing calls for enhanced support, so effectively the carrot, as it were, in the presence of those people who are not complying with that legislation are likely to come from sections of society, lower socioeconomic groups, perhaps less engaged in the trust process as well. So in circumstances where the laws can mandate behaviour and punish non-adherent behaviour, is there not a very strong risk that there will be an unequal, disproportionate impact on groups who are less able to comply with the laws than general public?
So that's a wonderful question, and you need to be careful. You're turning into a behavioural scientist. If you're not careful, you'll be up here. I learned many things during the pandemic, and one of the pleasures of being involved in the advisory process was learning by the other experts. And when it comes to behaviour, my focus has always been on the motivational dimension. Okay, so what is it that makes people want to adhere, to do things? And I've talked a bit, probably too much, about that today. Others point to the fact that adherence depends upon three things. It depends on motivation, certainly. It depends upon, in a sense, having the capabilities, the information, so you know what to do. And it depends critically on the opportunity, the support to do it. So early on, there was a study, I think it was in the spring of 2020, which showed that ethnic minorities and deprived groups are 3 to 6 times more likely to break lockdown. Nothing to do with motivation. Nothing to do with motivation, everything to do with the difficulties of more deprived and marginalised groups to stay at home and put food on the table. So support was critical. And it was critical from day one of the pandemic. So on day one of the pandemic, a new word entered the vocabulary, the word Covid-19. It was the first time it was used. And this was the problem of people going out and congregating in parks. And if you remember, photos of people in parks and Covid-19, look, they're congregating. Now, number one, those people were told that they were allowed to go out. Number two, if you're in an urban setting and you don't have your own garden, the only place you can go out is the local park. And if there aren't enough parks, then you're going to crowd. So what is your response? Is it to call people Covid-idiots? You're an idiot. Or is it to say, actually, let's support people to be able to do something that's good for health, to go out, and be distanced by opening more public spaces. SPI-B, and I myself argued time and again, support people. Support people so they can do what you're asking. And it has a double benefit. Number one, it allows them to do it. But number two, if I ask you to do something which you can't do because of your practical circumstances, all it does is it alienates you from me. It says, these people making the rules don't understand our lives. They tell us to do these things and we can't do them. So it undermines that social relationship fundamentally. So the issue of support, time and time and time again, was absolutely critical. And time and time and time again, we weren't given enough support. So the key issue here, because it's a key issue, as you've heard from many witnesses, was self-isolation. The whole point of the testing system, the billions spent on it, was not to test people, not to trace contacts, but to get people to self-isolate. And if you didn't get them to self-isolate, you were wasting your money. Okay. Now, the figures showed that people did quite a lot of things, and they adhered very highly in some areas. If you looked at the figures on self-isolation, it was as low as 18.2%. And the reason for that is it's an extremely difficult thing to do. And after saying support, 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 in the end, the UK government brought in a scheme, the £500 scheme, right, which A, was a small amount of money, B, only 1 in 8 workers qualified for it, and C, 67% of people who applied didn't get it. So it was a tiny amount of support. In other places, like New York, they had a wraparound system, whereby not only did you give people more money, you offered them hotel accommodation, you even offered them support to walk the dog, because that's quite important. If you're isolated, what are you going to do? So there was a critical need for support. Now, the Scottish government did a little bit more, but it didn't do enough. Now, whether that was an ideological issue or a financial issue, that given the financial settlement they couldn't afford to do it, I don't know. But I would argue that if I look at one of the major failures in Scotland, but in the UK as a whole, we didn't give enough support. And I just want to make one final point very briefly. Right? Jeremy Hunt, before he had his present exalted position, was chairing one of the parliamentary committees. And he asked Matt Hancock the question that we'd been asking: why was more support not given for self-isolation? And Hancock's response was because we were afraid that people would game the system. So again, this disrespect, this lack of confidence in people as being immoral and intellectually disabled, stopped us doing them. I wouldn't say the one thing, but an absolutely critical thing we should have done in order to make adherence higher in the most critical area of adherence.
And to be absolutely clear, you were giving that advice to Scottish Government through SCAG on a regular basis, weren't you?
You've already pointed out that at times I'm like a stuck record, and we were like a stuck record on SPI-B. If I give you every quote when we talk about isolation, it would be that long, and the same would go from the Scottish Government, from the Scottish Advisory Group.
Thank you. Just bear with me for one moment, please. My lady, I think my time is up.
Thank you very much, Salage. Thank you very much, Professor. Your passion comes through quite plainly. Thank you for your help.
Thank you.
My lady, I'm going to do some musical chairs now with
Certainly.
Mr. Tariq. Thank you very much.
Sincerely and truly
I do solemnly, sincerely, and truly
declare and affirm
declare and affirm
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Please sit down.
Good afternoon, my lady. May I please call Dr. Pablo Grez? Can I confirm that you prefer to be called as Dr. Grez?
That's correct. Thank you.
Thank you for your assistance to date with the inquiry. There are a few preliminary matters. Could you please keep your voice up and speak into the microphone so that a stenographer can record your evidence? If any of my questions are unclear, please say so and I will rephrase. You've provided a statement to the inquiry dated the 12th of December 2023. The statement is at INQ 000369759, and you'll see that it's on the screen before you.
That's correct.
Is this your statement?
Yes, it's my statement.
Are the contents of this statement true to the best of your knowledge and belief?
Yes, they are.
I now want to turn to your professional background before we get to the substance of your evidence. You're currently a lecturer in public law at the law school at Strathclyde University, is that correct?
That's correct.
And you hold an undergraduate law degree from Chile,
Yes.
a PhD in law from the University of Edinburgh, and a master's in public law from University College London, is that correct?
That's correct.
And you were previously a research associate at Birmingham Law School, is that correct?
That's correct.
During your time at Birmingham Law School, you worked on a project called the Pandemic Review, Right and Accountability in Covid-19, led by Professor Fiona de Londres, is that correct?
That's correct. I was part of a research team.
Who were the other members of the research team?
Well, Professor Fiona de Londra was the principal investigator, and Dr. Daniela Locke, currently at Oxford, and myself were research associates to that project.
If you could keep your pace slower so that your evidence can be noted. That project that you were involved with led to the establishment of the COVID Review Observatory, is that correct?
That's correct.
Are you able to tell me about the COVID Review Observatory and the aims of that project?
Yes. So the research project was mainly focused at looking at the ways how the different parliaments in the UK, either the Westminster Parliament, Holyrood, the Welsh Senate, or the Northern Ireland Assembly, to the extent to which they were holding governmental responses to COVID pandemic to account. There were a set of criteria we were interested in. We wanted to look whether these processes of review were evidence-based, whether they were participatory, and whether they were taking into account the human rights impacts that the responses led by the governments had for the rights of individuals.
We will come to your research shortly, but the project led to a number of publications, is that correct?
Yes.
And I think it says that 5 academic journal articles, 20 blog pieces, 16 submissions to the UK Parliamentary Committee inquiries, 6 to the Scottish Parliamentary Committee inquiries, 2 to the Welsh Parliamentary Committee inquiries, and 2 submissions to the UK and Scottish Government's consultation processes. Is that correct?
Yes, that's right.
Can we now turn to your statement? It's at page 3, paragraphs 6 to 7. I wanted to look at paragraphs 6 and 7. Paragraph 6 says, and I quote, "In my view, the COVID-19 pandemic is a textbook example of legitimate use of emergency powers, including delegation of emergency lawmaking powers to the executive. A pandemic requires an effective, fast and flexible response that keeps pace with the ever-evolving nature of the virus. The legislative process is designed to slow the pace of lawmaking by requiring a series of readings that prompt reflection, debate and improvements in the quality of legislation. Hence, the normal pace of the legislative process may not be suited for situations of emergency, although, as I explained below, an emergency may evolve, thus enabling a more paused lawmaking process. A framework of emergency powers must strike a balance between the need for an effective response to the emergency and the demands of constitutional principle. Among the latter is a requirement to secure parliamentary scrutiny of the governmental response. Parliament must hold the government to account for its COVID-19 policies, for instance, to ensure that the response is evidence-led, that whenever reasonably practical to do so, the government has consulted with relevant stakeholders, and that it fulfills the human rights requirements, while also not having a disproportionate and unequal impact on those rights." At a very kind of high level, what purpose does parliamentary scrutiny of the government serve in our democratic system?
Well, the starting point is that in this jurisdiction, this is a jurisdiction that abides by the idea of a constitutional democracy, and Parliament performs a key role in legitimizing the exercise of powers in this jurisdiction, either exercised by Parliament itself or by any other bodies, including certainly the executive. It is the role of Parliament to hold ministers into account for their policies, their spending, and the implementation of the policies. And that certainly takes place in the context of normal circumstances, but it should also take place in the context of exceptional circumstances, such as a pandemic.
In the context of exceptional circumstances, can the balance between the need to pass laws fast and the need for Parliament to scrutinise those laws change over the course of, say, a pandemic?
So when we are in the context of an emergency, there might be competing considerations at stake. Although we might want to protect to the extent that is possible the idea of parliamentary accountability, compromises might be needed in order to accommodate the situation of urgency. Our view in the COVID Review Observatory, after looking at the literature, the evidence, and the way how the pandemic developed through time, is that the balance between these considerations of expediency and effectiveness on the one hand, and constitutional principle on the other, is dynamic. We know that pandemics manifest themselves in waves. And there are moments where the virus spreads quite quickly and moments when that spread is more slowly. And there is room for their freedoms. Using an analogy, we could say also that this balance also manifests itself in waves. And at different stages of the pandemic, you can have different balances. We argue that at the very initial moment of the emergency response, the balance quite heavily shifts towards the need for an effective, fast, and flexible response. And therefore, unfortunately, there might be a compromise in terms of the level of scrutiny that Parliament, MSPs, or MPs might be able to perform. But our view is that as we go along in the pandemic, as we gain further knowledge of how the pandemic develops, as we gather further evidence, as we learn from our previous responses, this situation of emergency can shift towards a situation of crisis management. And in the crisis management, the demands of constitutional principle might weigh more significantly than those of effectiveness and flexibility.
So at the initial stage of the pandemic, at an emergency situation, the balance between the need to enact fast legislation, the balance might be different in terms of with the constitutional principles of parliamentary scrutiny and oversight. But as we move from that initial phase into crisis management, say for instance summer of 2020, the balance perhaps changes, it's dynamic. Do I understand that correct?
Yes, that would be an appropriate summary of what I'm trying to say.
I want to turn to the Scottish Government's legislative response to the pandemic. The response, the Scottish Government's response was enacted by way of primary and secondary legislation. Are you able to explain to me the difference between primary and secondary legislation?
Yes. So both primary and secondary legislation are different forms of lawmaking. From the point of view of constitutional principle, we could say that primary legislation is a superior form of lawmaking because it enables a full scrutiny of the policies that the government is trying to push forward and implement through legislation. Through, as in the statement that you quote was explained, through a series of readings which are designed in order to prompt reflection, paucity in lawmaking, engagement with potential stakeholders or individuals that might be affected by the legislation, and then taking into account all of these contributions as well as the potential impacts that these measures might have on the rights of individuals. By contrast, secondary legislation is a form of delegated legislation, whereby ministers are able to draft legislation and to enact legislation subject to a lesser form of parliamentary scrutiny, or maybe we can also call it a light touch parliamentary scrutiny.
And as far as the Scottish Government's response to the pandemic, the core of that response in terms of public health measures and international travel restrictions, that was enacted through secondary legislation, this being Scottish statutory instruments. Is that correct?
Yes. So in terms of the enabling framework, as you rightly mentioned, there are pieces of primary legislation coming from the UK Parliament, the Coronavirus Act. There are also two core pieces of primary legislation enacted by the Scottish Parliament, and exercising the powers contained in those pieces of primary legislation, the Scottish Government enacted public health regulations, which are those regulations that introduce most of the lockdown measures or any other restrictions that we all experienced, such as mask wearing, restrictions on gatherings, restrictions on businesses, etc., etc. And on the other hand, there was another piece of Scottish legislation, which you also mentioned, the Public Health, etc. Act 2008, which enabled the Scottish Government to introduce measures to restrict international travel from Scotland. So
before we turn to the legislation that was passed, could you describe to me the key milestones in the life cycle of a Scottish statutory instrument, this being the form that was used to enact most of the public health restrictions?
Okay. So we were distinguishing between two types of legislation, primary and secondary. Secondary legislation is legislation where most of the burden is on the shoulders of ministers who have these powers to enact regulations. They are subject to different sort of procedures, and therefore we distinguish different sorts of secondary legislation which is enacted through what is called the affirmative procedure, whereby the minister drafts the legislation and then lays the legislation before Parliament. Parliament has 40 days to approve that legislation or to reject that legislation, and that legislation won't enter into force unless Parliament approves it. Then you have the negative procedure, which is a procedure whereby ministers enact legislation and Parliament has a window of opportunity to reject those instruments. But if they don't approve it, that's okay. It can become law anyways. And there is also the made affirmative procedure, which is a very prominent procedure in the context of the pandemic, whereby ministers are able to make legislation that can enter into force even before Parliament approves it, but legislation that will lapse unless it is approved by Parliament within 28 sitting days.
So you've described 3 types of different procedures that can be used. There's the affirmative procedure, there's a negative procedure, and then the last procedure you touch upon is a made affirmative procedure.
That's correct.
And it's the made affirmative procedure that seems to be most prominently used by the Scottish Government across the pandemic. Is that correct?
Yes.
And I think the made affirmative procedure is described in some of your academic work as an extreme example of light touch parliamentary oversight, even more so than the other procedures. Is that correct?
Yes, and that's correct for a number of complex reasons. These procedures are a bit difficult to understand and digest, but I guess that the simple way to put this is to imagine that a Scottish minister drafts public health regulations which contain a series of measures that, for instance, prevent people from going outside their homes. They must stay at home. And that legislation enacted by a minister can enter into force almost immediately after being made, without the need for Parliament to discuss whether this is an appropriate measure or not, and to either manifest its approval to that decision or its decision to reject that measure. The measure will enter into force immediately and can last for up to 28 sitting days, as I said, unless there is an approval by Parliament.
So the way that made affirmative procedure works is that a minister, and we'll come to this shortly, decides to use that process. The regulations come into force almost immediately without there being a parliamentary debate or a vote. And then within 28 sitting days, there has to be a parliamentary vote on whether to approve the regulations or not.
Yes.
And if the regulations are voted down at that point, they no longer remain in force. Is that correct?
Yes, and you said that our view was that this was an extremely light touch procedure. And the reason for that is that, as you just mentioned, by the moment where Parliament will have a say on this set of regulations, the regulations would have been in place, being enforced, being followed, being in the media for days, weeks, and according to our research, even months before Parliament has an opportunity to have a say about the details of those regulations. And if that is the case, then we might want to wonder what would be the point of parliamentarians voting down a set of regulations that have been in place for days, weeks, and months. If I may expand on this, regulations come to Parliament under the made affirmative procedure as a fait accompli. The police has been enforcing these regulations for a long time. Guidance has been produced in order to illustrate citizens about their duties and obligations under this set of regulations. So it could be that, and it might well be, if the pandemic is evolving quite rapidly, that those regulations are about to be superseded by a new set of regulations, or there might be a change in the policy which might require those regulations to be amended. And that puts parliamentarians in a very difficult position. On top of that, parliamentarians might have other substantive reasons to be concerned about amending or rejecting those regulations. It might be that by rejecting regulations, they might undermine the overall response of the government to the pandemic, or it might be that they have a specific point or concern about a certain specific regulation or rule, but they are happy with the overall content of the set of regulations that is put to a vote, and they don't have the power to amend regulations. They can only accept them or reject them as a whole.
I think we'll come to some of the challenges that were faced by a parliamentarian when having to vote on regulations that have been enforced for at least 28 days. But before we turn to that, as far as I'm aware, the made affirmative procedure had been rarely used in the Scottish Parliament up to the pandemic. I think the Scottish Parliament's Delegated Powers and Law Reform Committee says that between 1999 and 2019, the procedure had only been used on average once or twice a year. Is that correct?
That's correct. It was very rarely used, and by contrast, it became the normal way of lawmaking during the pandemic.
And if we are able to turn to your statement, and it's at page 11, paragraph 36. And paragraph 36, and I think you say it became the normal way of making legislation during the pandemic. This says, to employ the made affirmative procedures, Scottish ministers must consider that the regulations need to be made urgently. A similar test applies in section 122, subsection 6 of the Public Health Scotland Act 2008. The test is subjective in the sense that there is no objective threshold or criterion. Rather, it is about whether the Scottish minister thinks there is an urgency situation. On the other hand, during the specified period, and that's for us January 2022 to April 2022, there was no ministerial duty to give reasons, for instance in the form of an oral statement before Parliament or a set of explanatory notes attached to a Scottish statutory instrument when laid, nor a duty to provide evidence in support of the ministerial assessment. Scottish ministers enjoyed discretion to decide whether on a given situation the urgency test had been met. Can we then turn to paragraph 9, which is on page 3, I think, or is it page 4? Page 4. And here you say at, if we can go to the last 5 lines of paragraph 9, you'll see there's a sentence that begins, the made affirmative procedure applies when a Scottish minister thinks that an SSI, that Scottish statutory instrument, needs to be made urgently. The consistent use of the made affirmative procedure throughout the pandemic indicates that the Scottish Government took the view that there was a more or less constant condition of urgency. In other words, from their perspective, there was never a shift from emergency response to crisis management. If we can take that off screen, thank you. Do you think that the Scottish Government overused the made affirmative procedure throughout the pandemic when there was other procedures such as the affirmative procedure that was available?
There's no easy answer to that question. As far as the enabling frameworks are concerned, the default position is that public health regulations should be made under the affirmative procedure. The made affirmative procedure is only available when a minister takes the view that there are situations of urgency justifying the use of this very exceptional procedure. If you look at the figures that are contained in our sample of Scottish statutory instruments that we looked at and the way how they had been handled and approved, or if you look at the data that the actual DISC inquiry has gathered, it looks like what was supposed to be under the framework, the exception, became the rule, because there is only one Scottish statutory instrument containing public health regulations that was made under the affirmative procedure. In other words, the made affirmative procedure was the default position. Almost all of the public health regulations were made under that procedure.
I think you've touched upon the research that you carried out. Can you explain to me, I think it was a sample size of 64 Scottish statutory instruments that you looked at. Can you explain to me how those were selected and which period they covered during the pandemic?
So we covered, since the very beginning of the pandemic, I think that the first instrument dates from the 26th of March of 2020 until I think that the end of November of 2021. And throughout that period, we were only looking at how lawmaking had taken place in terms of the public health regulations made under Schedule 19 of the Coronavirus Act 2020, which are what we could call lockdown regulations or, in general, restrictions to individual liberties.
Of the 64 regulations that were within your sample size, how many had been made using made affirmative procedure?
63.
I think we've already touched upon the discretion that the Scottish ministers had to use the made affirmative procedure. What was the Scottish Government's practice towards providing reasons for using this made affirmative procedure during the pandemic? And did that practice change as we moved into 2021 and into 2022?
There was no statutory duty to provide a statement of reasons, as you mentioned, justifying to Parliament why there were reasons of urgency, justifying the making of these instruments through the made affirmative procedure. There was a practice, although not consistent, of a Scottish minister providing a letter to the presiding officer of the Scottish Parliament with a brief indication of why it was, on the view of the Scottish ministers, justified to make those instruments through the made affirmative procedure. But there was not a statement that was attached to the instrument itself. The Delegated Powers and Law Reform Committee took the view that throughout the period of the pandemic, at least 5 statutory instruments had been made through the made affirmative procedure without a clear justification as to the necessity of using this very exceptional procedure. So here is one indication from Parliament that there might be instances where it was not justified. From our point of view, the very fact that there are alternative ways of making statutory instruments that are more respectful of the opportunities for Parliament to hold the government to account for its policies in the pandemic, that very fact suggests that a different approach could have been taken at different stages of the pandemic. In particular, we do understand the necessity of exercising the made affirmative procedure at the very early stages of the pandemic, but as we go through the pandemic, we think that there were less compelling reasons for exercising the pandemic, which, even though might satisfy the view of the Delegated Powers and Law Reform Committee, maybe from the point of view of constitutional principle, weren't sufficiently justified. If I can give an example of this, when the Scottish government publishes its policy frameworks outlining new strategies for approaching the pandemic, that provides a broad indication of what the direction of travel in terms of coronavirus regulation might be for the future, and therefore it would have been desirable that once the policy had been designed, also draft instruments could have been provided to Parliament, because eventually it would be through a draft, through a statutory instrument that those broad policies would be implemented in detail. This is not only our view, this is also the view of parliamentary committees at the UK Parliament.
We've touched upon the 28-day period. What did your research show about whether there was, in fact, a 28-day period by which the regulations were brought before Parliament for a vote, or was it often more than 28 days?
So we took this sample of 68 statutory instruments, and we identified certain milestones in the life cycle of a statutory instrument, being those when the instrument is made, when the instrument enters into force, when the instrument is approved and debated, if it is debated. And what we found in terms of your question is that only there were very, very exceptional circumstances where the Scottish government did not comply with the 28 sittings, 28 rules, 28 days rule. A different question is whether there was always adherence to the spirit of the rule. The spirit of the rule is to bring those statutory instruments to a parliamentary vote as soon as it is reasonably possible to do so. And there were instances where that didn't happen.
One of the issues I think you've raised in some of your writings is the risk that it's possible to chain regulations together, so that by one extending the expiry dates of the other. So in effect, you have one regulation which is due to expire on a certain date, and it requires a vote, and then it's superseded by another set of regulations which extends the expiry date. So the concrete set of regulations or rules remain in force for longer than the 28 days by chaining regulations together, and all of this being without subject to a parliamentary vote. Are you able to explain that concept in more detail?
Yes. So we will have to imagine a situation where a Scottish minister makes a set of regulations in day one, and from that day, that set of regulations will enter into force potentially immediately or at a day that the minister might designate, but it will have to be approved by Parliament before 28 sitting days. Otherwise, it will lapse and it will no longer be in force. We identified one situation where that had happened, and before that 28 sitting days period had lapsed, and before that instrument had been approved by Parliament, a new instrument, Instrument 2, had been made which extended the lifespan of the first instrument. And therefore, the 28 sitting days period will be reset. And it will be a new 28 sitting days period that will be operating now. So potentially, theoretically, one weakness that this finding unveils is the possibility of constantly evading parliamentary scrutiny through enacting a set of regulations and then extending the expiry date of that set of regulations through different new regulations that will renew the 28 days period. We don't argue that this possibility was abused by the Scottish Parliament, by the Scottish government, I'm sorry. There were specific reasons why that had to be the case in that specific example that you mentioned. However, it does indicate that there might be a weakness in the procedure itself that might need to be dealt with in future legislation.
I now want to turn to the issue of debate. So when one of these regulations is brought before the Parliament, can we turn to page 17 of your statement at paragraphs 56 and 57? So if I can read paragraph 56. The made affirmative procedure had a significant impact on the Chamber's ability to retrospectively scrutinise public health measures, when motions to approve Scottish statutory instruments were moved, MSPs were asked to consider public health regulations that had been enforced for weeks, if not months in some cases. By the time the vote took place, the Scottish Government had already published guidance to communicate the contents of the regulations to the public, which was further communicated by the media. Hence, people, business and workplaces were abiding by these regulations and the police enforcing them. For this reason, at the CVRO, we argued that Scottish statutory instruments made under the Made Affirmative procedure came before the Parliament as a fait accompli. I think there may have been other reasons why MSPs refrained from voting against Scottish statutory instruments. For instance, MSPs could take the view that voting down a Scottish statutory instrument could confuse the population, as it would require a new set of regulations to be put in place very quickly. It could undermine the overall pandemic response and the trust of the public in governmental decision-making, and/or it could be that they only had specific objections concerning some but not all of the rules enacted by a set of public health regulations, and an all-or-nothing vote on the Scottish statutory instrument did not accommodate those distinctions. The final point there is, when it comes to a vote, there isn't an ability to amend the regulations, is there?
That's correct.
So it's a binary choice that you either vote to keep the regulations in force, or you vote to withdraw the regulations. Is that correct?
That's correct.
In your research, in the sample size that you used of 64 Scottish statutory instruments between March 2020 and November 2021, were any of the Scottish statutory instruments made using the Made Affirmative procedure voted down by a majority of the Scottish Parliament?
No. Our finding is that during the pandemic, Scottish statutory instruments containing public health regulations were virtually invincible because they would never be voted down.
And I think in your research, it shows that only 9% of the regulations in your sample size were debated in the chamber of the Scottish Parliament. Is that correct?
Yes, that's correct. Regulations containing public health measures were very rarely debated. For a regulation to be debated, there will be a need for an MSP to raise a point of concern about the broader policy containing that set of regulations, or about the content of the regulations themselves. And there were a few examples of MSPs concerned about the procedure as a whole and trying to make a point by promoting a debate.
In the 9% of these regulations in your sample size that were debated, what was the typical length of the debate?
Well, debates were quite short. They would last between 5 to 10 minutes.
And I think you say in your statement that in total, the Scottish Parliament spent 35 minutes debating the 64 Scottish statutory instruments. Is that correct?
That's correct.
So that's 35 minutes debating the regulations in your sample size that were passed between March 2020 and November 2021.
Yes, that's as far as the chamber is concerned.
The inquiry understands that from autumn 2020, there were concerns about the lack of parliamentary oversight of the regulations that had passed. Particularly, these are regulations pertaining to the first wave of the pandemic from March 2020. And parliamentary and government officials engaged in conversations to enhance parliamentary scrutiny. What package of measures were introduced from autumn 2020 to tip the balance more towards parliamentary scrutiny?
So there were two main types of measures. The first, and maybe the more important one, I will say, were those that were trying to design or craft a system that will enable MSPs to conduct what we could call pre-enactment scrutiny of statutory instruments made under the Made Affirmative procedure. And the dynamic that was agreed was one where the Scottish Government will commit to make a policy announcement regarding public health regulations on a Tuesday afternoon. Usually they will reconsider whether changes were needed on that very Tuesday in the morning. Then they will make available to Parliament a draft set of regulations that will be later be made under the made affirmative procedure on a Wednesday. Then Scottish ministers and senior civil servants will be made available to attend a session at the either COVID-19 committee or the COVID-19 recovery committee, depending on whether we were in session 5 or 6 of the Scottish Parliament, to give evidence and answer questions arising out of this draft set of regulations, which would be then made into law either on a Thursday evening or on a Friday, and might potentially enter into force the next day.
So could you explain in a bit more detail the role of these committees, this being the COVID-19 Committee of the Scottish Parliament, which then later became the COVID-19 Recovery Committee, in terms of parliamentary oversight?
The Scottish Parliament, being an unicameral parliament, relies quite heavily on the contribution of its select committees to perform a scrutiny not only of policies and its implementation, but also of legislation. And the scrutiny of primary legislation and certainly of secondary legislation relies significantly on the work that these committees perform. The Delegated Powers and Law Reform Committee performs technical scrutiny. It looks at the virus of the instrument. It looks at any other technical issues that might arise, such as lack of clarity and aspects of a similar nature. And then there is a lead committee, which is usually the one that, in terms of the policy, matches the remit of the committee, which will look at the policy implemented in that instrument. During the pandemic, the Scottish Parliament decided to create a bespoke COVID-19 committee, which will look at the policies in terms of the pandemic, and it was that committee, the one that was in charge of scrutinizing those instruments in more detail.
There's a particular instance of the Scottish Government's use of the made affirmative procedure which I want to explore with you. In summer 2021, the COVID-19 vaccination certificate scheme was being considered, and the certificate scheme policy was announced in Parliament by Nicola Sturgeon on the 3rd of August 2021. Then on the 9th of September 2021, the Chamber in the Scottish Parliament debated for around 2 hours a motion on the COVID vaccine certification scheme. And the motion provided very broad guidelines on how it was proposed that the policy would work. And in addition, the government had published, I think it was a plan or strategy with the proposals. So it was at a very high general level about how the policy would work. And the debate was a clear indication that the proposal was fraught with difficulties, because the Scottish Conservatives, Scottish Labour and the Liberal Democrats all voted against the motion. However, despite this being an issue that was fraught with controversy and difficulty, the Scottish Government used the made affirmative procedure on the 30th of September 2021, and the regulations came into force on the 1st of October 2021. And I think speaking about some of the improvements that had been made to parliamentary oversight, the government had shared a draft of the regulations with members of the Scottish Parliament to scrutinise only 1 day in advance of the regulations being made. That was the 29th of September. So what we have here is a policy announcement made on the 3rd of August 2021. There seems to be quite a lot of political controversy. And then the regulations are introduced using made affirmative procedure. And they're introduced, that's the operational regulations with all the details of how the scheme would work in practice, all without an ability of the Scottish Parliament to debate the details of the policy. What was the urgency that between the 3rd of August and the end of September that required this procedure to be used as opposed to, for instance, the affirmative procedure?
Well, the example that you provide is a case in point of the tensions that in terms of parliamentary scrutiny arose, and the dissatisfaction that at certain points in time rightly members of the Scottish Parliament had towards the way how lawmaking was taking place in the pandemic. There had been a policy announcement more than a month in advance of the detail of the implementation of that policy being put to Parliament. And there was also, as you say, a debate on the policy, which had been preceded by a publication of a more fully fledged policy document outlining the content of the policy. And the Scottish government was aware of the fact that there was some dissatisfaction, certainly among certain political parties in the Scottish Parliament represented, over the policy. So it is hard to understand why those regulations containing the details of that policy that had been controversial had not been shared in advance with the COVID committee and other members of the Scottish Parliament. What you mentioned at the very end shows that what they did was to apply the measures, the enhanced scrutiny measures, but it was clear that a different approach was possible because that policy had been worked out by weeks at that time.
Overall, should the made affirmative procedure be used or exercised with caution and self-constraint because of the extremely light touch parliamentary scrutiny that exists if you use that procedure?
I would agree with that claim. I think that the governments in general should exercise more caution when deciding whether to make certain sets of regulations through the made affirmative procedure or whether to opt for a different procedure. In fact, you were referring to the example of the COVID certificate scheme. When the COVID certificate scheme was amended, since it had been controversial, those amendments were introduced through a statutory instrument that was made under the affirmative procedure. And although there were still certain considerations of urgency that needed to be taken into account, an agreement was reached between the government and the COVID-19 Recovery Committee to have an accelerated timetable to introduce those amendments through the affirmative procedure. So the standard affirmative procedure provides 40 days for Parliament to approve regulations in draft. In this case, it was agreed that it will have only 4 days.
Before we turn to lessons learned, in the context of a pandemic where the government and then Parliament were having to consider legislation that was perhaps some of the most draconian that people have ever had to live through, is that the sort of scenario where, in fact, even more caution and self-restraint is required, which comes with more parliamentary debate, so that better legislation can be passed that is evidence-based?
I will go back to the idea that there needs to be a compromise and we need to look at on the ground what the circumstances are in order to assess whether we need an emergency procedure for the making of legislation in a given context and circumstance. There might be circumstances where we need a rapid response, where the virus is evolving too quickly or there are many uncertainties, and therefore there is justification for using the made affirmative procedure. There might be other situations where that might not be the case. The made affirmative procedure should be on the toolkit, I would argue, but as you said, should be exercised with caution.
And I think that's a distinction that you've made between the initial phase of the pandemic and then moving into the crisis management phase, where there is a little bit more time and scope to have better parliamentary scrutiny. Is that correct?
Yes.
And I want to finally turn to lessons learned. And the inquiry understands that from June 2022, the Scottish Parliament passed the Coronavirus Recovery and Reform Scotland Act 2022, which reflects some of the lessons learned during the pandemic. Are you able to outline the main changes that now exist from the legislative framework that existed at the start of the pandemic?
So during the first semester of 2022, the Scottish Parliament had the opportunity to discuss different ways of improving the enabling framework. It was a decision of the Scottish government to make the powers granted by the UK Coronavirus Act part of Scottish legislation for future pandemics. And in the context of introducing that legislation, some improvements were made. The first and maybe more noticeable improvement is to demand from Scottish ministers in the future to make a statement of the reasons that support the urgency of making regulations under the made affirmative procedure, a requirement that was absent during the pandemic and that the Covid-19 committee advocated very strongly in favor of. On top of that, to trigger these emergency powers, now the Scottish government has to do a declaration of public health emergency, which is subject to a vote in the Scottish Parliament. So now there needs to be a say for MSPs in order to trigger this set of emergency powers. And there are duties to consult relevant stakeholders whenever it is feasible or possible to do so before enacting public health regulations. And finally, wherever Scottish ministers exercise their powers to make public health regulations under the made affirmative procedure, there is a duty to introduce a sunset clause so that the regulations expire at a certain point in time.
So you would welcome all of those changes in terms of striking a better balance. In your statement, I think you say that your view remains that more can be done to achieve a better balance in use of these procedures in a future emergency situation. I think you identified two alternative pathways which you recommend for consideration. The first is in terms of preparing for a future emergency to amend the statutory framework so that different levels of public health response are outlined in primary legislation with delegation to trigger these powers through secondary legislation. Can you explain that suggestion in more detail?
So I think that during this inquiry, a lot has been spoken about pandemic preparedness from the point of view maybe of material resources, but maybe we can also think about pandemic preparedness for the future in terms of legislative and regulatory measures that might be in place in the future. A lot has been learned in terms of what are the sort of broad responses or broad principles that should govern the emergency response for future pandemics. And perhaps there is therefore an opportunity to not only improve our procedures, but also to give Parliament a say or an opportunity to reflect on how the substantive response should look like. And we envisage at least two ways in which that could be possible. One way would be to incorporate into primary legislation some core elements or principles of, for instance, a tier system of lockdown regulations, certainly providing certain flexibility for the government to tailor the specificities of that response to the circumstances that are at hand, or alternatively, to draft future public health regulations that are subject to scrutiny. We have some information that the Coronavirus Act took some elements of legislation that had been drafted in the context of a SAGNUS exercise. So perhaps a similar effort can be made to draft regulations. Or alternatively, we can think of different ways of accommodating the affirmative procedure to a more constrained timetable, but providing an opportunity for Parliament to have a say before regulations are made and enter into force.
Your second recommendation was to incorporate a ministerial duty on the exercise of emergency powers every 2 months. Are you able to explain that proposal?
The Scottish Government developed a quite robust, I will say, practice of reporting on the exercise of the powers under the UK Coronavirus Act and the two Scottish Coronavirus Acts. Those reports provided information of what measures had been taken, how many statutory instruments had been made, when they had been made, what evidence had been taken into account to support those measures, and also, I would say also a significant engagement with the human rights impact of those legislation. Each of those reports were preceded on their publication by a statement made by a relevant senior member of the Scottish Cabinet to Parliament, which would introduce very briefly what the content of the report was, and then there would be opportunity for questions. And on top of that, the COVID-19 committee had the opportunity to scrutinize in more detail those reports. Parliamentary accountability, to be possible, it needs to be enabled by the government. Transparency and information about what the evidence is, what the impacts of the measures are, et cetera, are essential to enable MSPs to hold the government to account. And in that sense, I think that this was a practice that should be kept in mind and should be operating in future pandemics because it was of a good quality.
My lady, there's no further questions from me. I understand there's no live Rule 10s. So on behalf of the inquiry team, I can just thank you, Dr. Grace, for your evidence today.
Thank you very much, Dr. Grace. Very helpful. Thank you. I shall return at 3:15.
Good afternoon. May I please call Professor Susan McPhee?
Stand for me, please, and repeat after me. I do solemnly, sincerely and truly
I do solemnly, sincerely and truly
declare and affirm
that
the evidence I shall give
the evidence I shall give
shall be the truth,
the
whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you. Please sit down.
I hope we haven't kept you waiting too long, Professor. I'm very sorry if we have.
Not at all.
Good afternoon, Professor McPhee. There are a few preliminary matters I wanted to touch on. Can you please keep your voice up and speak into the microphone so that your evidence can be recorded by the stenographer? Is that okay?
Yes, that's fine.
And if there's any question that I ask which is unclear, please say so and I will rephrase or repeat the question. You've provided the inquiry with a witness statement dated the 15th of December 2023, the 12th of December 2023. The statement is at INQ 000369767. You have the statement on screen. Can you confirm if this is your statement?
Yes, it is.
Are the contents of this statement true to the best of your knowledge and belief?
Yes, they are.
I now wanted to turn to your professional background, Professor McPhee. As I understand it, you're a professor of quantitative criminology in the School of Law at the University of Edinburgh. Is that correct?
That is correct.
And you've held that position since 2010. Is that correct?
Yes.
I know about criminology, there's a surprise, but quantitative criminology, what's the difference?
Well, I mainly focus on large research projects involving quantitative data, large administrative data sets, surveys, that sort of thing.
And I anticipate coming to some of that data.
Okay. Sorry if I preempted your questioning, Mr. Terry.
Prior to this, you were, I believe, a research fellow and then senior research fellow in the criminology branch of the Central Research Unit in what was at the time the Scottish Office and is now the Scottish Government between 1992 and 1997. Is that correct?
That is correct.
And then you became a senior research fellow at the law school at Edinburgh University from 1998 before you ended up in the position that you currently hold. Is that correct?
That is correct.
So you've had over 25 years of experience in academia. Is that correct?
Yes.
And you have many publications in the field of criminology, including policing policy and practice and crime trends and patterns. Is that correct?
Yes, that's right.
And you've been involved in many advisory committees for governments in Scotland, the wider UK and internationally. And this includes membership of 2 prior independent advisory groups on Scottish policing on the topic of stop and search powers and police use of biometric data. Is that correct?
That is correct.
And in the context of the pandemic response, you became a member of the Independent Advisory Group on police use of temporary powers related to the coronavirus crisis in Scotland from the inception of the group in April 2020. Is that correct?
That is correct.
And you remained in the group until it was formally disbanded in May 2022. Is that correct?
Yes.
We are going to come back to the work of the Independent Advisory Group, but you're also the principal investigator for a research project titled Policing the Pandemic in Scotland. Is that correct?
Yes.
Are you able to tell me about this particular project?
Of course. The project arose out of the work that I'd been doing for the Independent Advisory Group, where I had been tasked with using police data to analyse patterns and trends and the characteristics of individuals who'd been subject to enforcement. At the time, there was a funding opportunity for rapid response projects that would be used to help inform policymakers and ministers about the impact of the pandemic. So I was fortunate enough to receive funding and I conducted research with a small team of colleagues looking at a detailed analysis of the data that we had around police use of enforcement in Scotland. We conducted interviews with a number of police officers and we conducted interviews with a small number of members of the public who'd been issued with fixed penalties, but that particular piece of research didn't work very well because we didn't have very many people willing to take part. But we've also done research that involves linking police data with health data, which has allowed us to look in a bit more detail at the underlying health vulnerabilities of those who were subject to enforcement.
I will come to that piece of specific data shortly. But I think you've said that in the context of your project, you've interviewed members of the police. Is that correct?
Yes.
And was that in relation to policing during the pandemic?
Yes.
And this is in the context of Scotland, is that correct?
Yes.
Do you know roughly how many police officers you would have interviewed in the context of that project?
I think we interviewed around 30.
And you're also, and we'll come back to the project, but you're also, in terms of your current roles, are you a consultant to the National Police Chiefs Council on the police use of enforcement in England and Wales?
I was given a consultancy to do work on producing a report for them on their data on police use of enforcement, yes.
Having set out your background, I wanted to turn to the Independent Advisory Group. This is the Independent Advisory Group on the police use of temporary powers related to the coronavirus crisis in Scotland. And this advisory group was established by the Scottish Police Authority at the request of the Chief Constable of Police Scotland. Is that correct?
Yes.
Are you able to explain to us the difference between the Scottish Police Authority and Police Scotland?
So the Police Service of Scotland is the single unitary police force for the country. It was previously 8 legacy forces which were merged together into one single force in 2013. And at that time, the Scottish Police Authority was established as the scrutiny body to examine police activity, police use of its powers, and to monitor how policing was being operationalised and developed in Scotland.
So this independent group was effectively set up by this oversight or monitoring body, this being Scottish Police Authority, is that correct?
Yes, the Scottish Police Authority provided the secretariat to the group, and the Independent Advisory Group reported back to the SPA, but Police Scotland were very core participants in the group.
In general terms, what was the remit of the group?
Our terms of reference were specifically to look at the police emergency powers that had been issued, so the powers of enforcement, and we were asked to examine the policing of the pandemic in the context of human rights, and also to ensure that enforcement had been administered in line with policing values and principles in Scotland.
Why was there a need for this group?
I believe that the Chief Constable, of course, I mentioned that Police Scotland had only existed since 2013, and in its short lifetime, there had been a number of fairly high-profile inquiries into specific aspects of policing, including 2 advisory groups that you've already mentioned on stop and search and police use of biometrics and data. I think the Chief Constable was acutely aware that it was likely there would be scrutiny around police use of these new extraordinary powers, because the police were being asked to enforce activities that under normal circumstances would be completely law-abiding behaviours. So he was keen to ensure that, that there was an independent group that would provide scrutiny, public transparency, and enable the organisation itself to learn from any aspect of the policing work that was being undertaken.
So one of the purposes was to effectively learn in real time what was happening and what could be improved during the pandemic?
Yes.
Who were the other members of the group?
The group was chaired by John Scott Casey, now Lord Scott, and he invited a range, or in fact, it was David Crichton, who was the Chief Executive of the Scottish Police Authority at that time, invited a range of individuals to join the group so that it would have quite a broad membership. Do you want the exact list? Because I can refer to my notes for that, or I can try and remember them off the top of my head.
I don't need a complete list. It
Okay.
was just trying to get a range, what range of experience or expertise was on the group.
Okay, so Police Scotland and the Scottish Police Authority, I've already mentioned. There was a representative from Public Health, a representative from the Crown Office, the Crown Agent sat on the group. The Chief Inspector of Constabulary sat on the group. There was membership from a range of third sector organisations, including the Glasgow Disability Alliance and Scottish Women's Autism Network, and there were representatives from a number of human rights and equalities organisations, in addition to myself, and Mr Anwar was a member of that group.
How frequently did the group meet during the pandemic?
In the early days of the pandemic, it met very frequently, at least twice a week, sometimes more frequently than that if there were specific issues to be discussed. Over time, we met less frequently, although at least once a week, up until around the end of 2021, and then beyond that we met a bit less frequently until the group was formally disbanded in May 2022.
Did the group receive regular updates or input from senior police officers about some of the issues that they were facing during the pandemic?
Yeah, excuse me. Yes, it did. Deputy Chief Constable Will Kerr attended certainly regularly at the beginning of the pandemic, a bit less so later on, but he was a frequent attender. And Assistant Chief Constable Gary Ritchie was present at the vast majority of meetings. There was always a police presence. We quite often had senior representatives from different divisions as well, usually at Chief Superintendent level. And we were also furnished with a secretariat called the Optical Group. Don't ask me to repeat what optical stood for because I've forgotten, but it was essentially a group that was providing us with data, information or any intelligence that we needed in terms of our work.
How did the group report its findings or recommendations to the police?
We, internally within the group, we produced a number of reports. Different members of the Independent Advisor Group produced reports on specific themes. I, for example, produced quite a number of data reports. And the chair of the group, Lord Scott, was responsible for reporting back to the Scottish Police Authority. So all of the work that we undertook and the detailed reports that were produced by Lord Scott and any other work we'd conducted, such as some of my data reports, were formally presented to the Scottish Police Authority through their board meetings, and so they were discussed by the SPA and Police Scotland.
In your statement, you explained that, I think you say you were the only academic on the group, which meant that you took on a role of amassing evidence and advising on research which could help to inform policing practice. You also say that you examined the police use of these new powers under the coronavirus regulations from an empirical perspective. And I think you say there was a significant amount of data for you to use. What were the sources of data that you used in your research?
So do you mean the research project or the work of the independent advisory
group? The work of the
group?
independent advisory group.
In the independent advisory group, Police Scotland had, with a great degree of foresight, I might add, had decided to create a coronavirus intervention system to measure the extent of the encounters it was having with members of the public. In one of my previous groups, I had been involved in advising around the collection of data and the publication of data on stop and search. So having good data and knowing what the data was telling them about their own activities, I think was something that was quite high on their radar. The Coronavirus Intervention System, as it was called, or CVI system, allowed us to analyse the relative use of enforcement compared to other aspects of activity. I can speak to the 4 E's approach later if you wish, but the purpose was to understand to what extent were officers engaging with members of the public around the coronavirus regulations, and how often were they resorting to use of enforcement. I also had access to individual level data about individuals who had been issued with a fixed penalty notice. So I had personal information about not about their identities, but about their age, their sex, their ethnicity, that sort of thing.
And all of that allowed you to pull together a series of reports that you produced as a member of the Independent Advisory Group, is that correct?
Yes, that's right.
I want to turn to the use of fixed penalty notices, because it's a subject of, I think, significant number of reports that you've produced along with others. And I'm talking about the use of fixed penalty notices in the context of enforcing public health restrictions in Scotland. Just to be clear, a fixed penalty notice is an on-the-spot fine. It's not a criminal conviction, but they are recorded on police systems and may be disclosed via an enhanced disclosure application within a certain period of time. Is that correct?
Yes.
So are you aware of the rationale for using fixed penalty notices as a means of enforcing public health restrictions in Scotland during the pandemic?
Well, I'm aware of the kind of the general rationale for using fixed penalties at the level of why they were considered expedient and a good model. It's less clear what the purpose of the fixed penalties was supposed to be. That's never really been properly explained in terms of if you were to have a metric of success, for example, it's difficult to know what that metric would be. Is it the speed of the spread? Is it the number of individuals who have the virus or who have sadly passed away?
You say that about a lot of the sentencing within the criminal justice system.
Indeed. But in terms of the rationale, it was explained by Kit Malthouse MP, who was the UK Government Minister for Policing. It was explained as a kind of expedient model of using enforcement that would be familiar to the public. It had a number of appealing aspects to it. It has an established level of legitimacy. The public know what an on-the-spot fixed penalty is. They understand it. They accept that these types of penalties exist. As you mentioned, it means you don't criminalise people because you don't get a criminal record. It represents a relatively minimal administrative burden for both the individual who receives the fine and also for the police themselves. And it keeps people out of the criminal justice system, which was important in the context of the pandemic. I think the more people being kept out of the system was considered important. And actually it did, because the data in Scotland specifically show that only 121 people, I think, were subject to criminal proceedings up to March 2022 under the coronavirus regulations, and only 5 went to prison. In relation to why were they used in Scotland specifically, that is because they were proposed by the UK government, and at the beginning of the pandemic, when there was a discussion about the extent and the nature of the regulations that would be put in place, there was a high level of commitment from Scottish Government to be part of a 4 nations approach. So they were proposed by the UK Government and they were accepted. There's not really anything in any of the correspondence that I've seen to suggest there was ever any question as to their use.
I think you say in your statement that fixed penalty notices are most suitable for clearly defined objective offences that involve minimum discretion on the part of police officers.
Yes.
One example might be, for instance, speeding.
Yes.
It's a binary issue of whether you're speeding or not. And you say that their use to enforce public health restrictions during the pandemic was a departure from this traditional model. Can you explain why it was a departure from this traditional model?
It was a departure because, as you say, fines are typically used for well-defined, either well-defined low-level offences, including speeding, or they might be used for antisocial behaviour offences, which can be broader, but there's a lot of case law. So there's a good understanding about what is and isn't an offence in relation to antisocial behaviour. The issue in relation to the COVID fines was that the extent to which the fines might be used in the types of behaviour that they might be issued for was not necessarily always clearly defined. It changed a lot over the course of the pandemic as the regulations changed, and it was not always clear to either members of the public or police officers themselves what was a breach of the law and what was merely a breach of guidance, for example. So it was problematic from the point of view that neither the individual nor the police officer might have a clear view of whether an offence had actually been committed.
What would have been the alternatives to using fixed penalty notices as part of the pandemic response?
Well, I certainly wouldn't have advocated for anything further into the criminal justice system. Formal warnings could have been used. We've seen from the data, if you look at trends over time in the use of police fixed penalty notices, they've been going down for the last decade or so, both in Scotland and in England. I mean, they declined quite markedly by something in the region of 80 to 90%, whereas the use of formal warnings or community dispute resolutions in England have been increasing. So it felt a bit strange for us when we were looking at the decision to introduce fixed penalties, that was against the prevailing trend of summary justice measures in Scotland. But of course, because they were following the English model, then that would explain that. But they've been going down in England as well. So a formal warning could have been used. That has been recommended in some literature in the US, that warnings are a better approach because the vast majority of people only had contact with the police once, and so therefore a formal warning wouldn't have resulted in some of the inequalities that are inherent in a financial penalty.
We will come to those inequalities. In your research, have you seen any evidence as to the additional benefits of using sanctions in addition to guidance, such as in terms of public compliance with the measures?
So we haven't specifically researched that, and it would be quite difficult to research that in the Scottish context because of the blurring between rules and guidance, and because of the multiple changes to the rules over time, it's actually quite hard to disentangle what would have made a difference. The vast majority of countries did follow a sanctions-based model, and I think that probably is one of the reasons that the UK government decided to go down that particular route. There are not very many countries that have focused only on guidance. South Korea is one, but it's a very, very compliant population.
You give the example of, is it Sweden,
Yes.
in one of your research, that focused not on the sanctions model, but on the
Yes.
guidance model.
That's right. And Sweden is often used as a comparator to Scotland because we're, similar hemispheres, similar population. Sweden decided not to use sanctions. They didn't introduce a lockdown. They banned large gatherings, travel, and social. They recommended social distancing. They didn't lock down the schools immediately. They didn't introduce face masks immediately. They took a much more kind of what you might describe as a lenient approach to managing the pandemic. It wasn't without controversy in Sweden, and many scientists were critical of the government for not introducing some kind of enforcement, and claimed that the lack of enforcement would lead to an increase in the death rate. However, a study that's been conducted fairly recently has identified that the death rate in Sweden was relatively low compared to other comparator European countries, including the UK. It's almost half the rate in Sweden that it was here. So there's evidence, there's no clear evidence to suggest that you need enforcement in order to make people comply. It was considered more of a...
Sorry,
Yes.
You say comparative countries. I mean, I've been down this road before. Comparisons are very difficult to make.
Yes.
Sweden's population probably far more dispersed, don't have the as many major cities where people are densely. It's really difficult to make a comparison between different countries.
Absolutely. And actually the level of social support for individuals who may have struggled to comply in Sweden would have been higher. So, I mean, I think what I would say is it's very difficult to know within the UK context whether a guidance-only model would have worked. But in the event, it was never really considered.
Yeah. In your report, and we're going to come to the report shortly, I think you say it's been very difficult to tease out the effect, if any, that enforcement had on preventing the spread of the disease or saving lives. You say that as a principal reason for introducing new policing powers during the pandemic, this does raise questions about testing the efficacy of an enforcement-based model to reduce the spread of the virus. Does that still remain your view? And if so, can you explain your position?
Yeah, so the position is based on the original statement that was made by Priti Patel MP when the enforcement was introduced, and she made a statement regarding the use of enforcement, and she specifically said that the use of enforcement would help to reduce the spread of the disease, protect the NHS and save lives, which was the kind of mantra at that time. And we don't really have the data that would be necessary to try and determine the cause and effect of the use of police enforcement on patterns of death. But I have mapped it, and what you see is that as the death rate increased, the number of fixed penalties increased, and then as the death rate reduced, the number of fixed penalties reduced. So it tracks pretty closely up until about February 2021, at which point the beneficial effects of the vaccine kick in and the death rate drops down quite considerably. But the rate of enforcement continued to be high for another couple of months. There's no evidence that more enforcement led to less deaths and less spread. And in fact, from a logical point of view, the police couldn't know where the virus was or how it was spreading or where it was spreading any more than anyone else could. I think the police role was really more about kind of, trying to mitigate potential negative effects of people being in close proximity together rather than the specific impact on the death rate. I mean, and for example, if a police officer was faced with two individuals, one of whom had a reasonable excuse and wasn't issued with a fixed penalty, and another didn't have a reasonable excuse and was, the officer had no way of knowing which of those two individuals may, if any, have COVID. So I think it was a kind of false impression to link that kind of public health impact with the enforcement itself.
I understand, I'm turning to a new topic, I understand that one of your colleagues on the project sent a Freedom of Information request to the Scottish Government.
Yes.
And what your colleague was seeking to do was looking for correspondence, notes and briefings relating to the decision to include fixed penalty notices as a penalty for breaching coronavirus regulations. I don't intend to take you through each of the pieces of correspondence. You've produced them to the inquiry, but in general terms, what did the correspondence show in terms of the Scottish Government's thinking around the use of fixed penalty notices?
So the correspondence showed that the Scottish Government were committed to a four nations approach. So when the UK Government provided their model of enforcement, the Scottish Government were predominantly interested in considering whether it could be operationalised within Scottish legislation and within the model that operates in Scotland. Information was shared with Police Scotland, with the Scottish Courts Tribunal and with the Crown Office. So there was a view from the criminal justice organisations in Scotland as to how appropriate it was. The main discussions in terms of questions to ministers were around the value of the fine, whether to stick with the existing antisocial behaviour legislation and model the fine around that, whether to retain the value of the fines for antisocial behaviour or adopt the proposed value from the UK Government, because the values were slightly different, and also there was an issue around the whether fines should be issued to 16 or 17-year-olds, because the UK Government had proposed that fines be issued to individuals aged 18 or over, but the antisocial behaviour legislation in Scotland allowed for 16 and 17-year-olds to receive fixed penalties.
I understand from what you say in your statements and looking at some of the correspondence that at the start of the pandemic there was a difference between Scotland and the rest of the UK in terms of, this is Regulation 9 of the Health Protection Regulations in Scotland, that allowed fixed penalty notices to be issued to people aged 16 or over, whereas the position across the rest of the UK was that fixed penalty notices could only be issued to people 18 years or over. And in those documents, that seems to be a conscious decision, a deliberate decision that's made by the Scottish Government to use the existing model of the antisocial behaviour so that these penalties can be issued to 16-year-olds. Is that correct?
Yes. I think the decision to model the COVID fixed penalty on the existing legislation was partly a practical one. The police were used to issuing antisocial behaviour fines, so therefore using the same kind of broad model, it made sense. If they were in a position where they were having to issue some fines to 16, 17-year-olds and not others, I think there was a feeling from Police Scotland that, you know, that would cause some confusion. And also, I think it was expressed in that particular document that Police Scotland were concerned that younger people may pose a problem in terms of being in large groups and potentially spreading the disease. So in some ways, I think Police Scotland had quite a big influence on the decision to maintain to maintain 16, 17-year-olds within the legislation as opposed to the English legislation.
And the inquiry understands that the Coronavirus No. 2 Scotland Act then amended Regulation 9 to raise the minimum age to 16, and that act came into effect on the 27th of May 2020. So within a couple of months of initially deciding to go with the age of 16 years, this was increased to 18 years. And I think in that time there had been calls from the UN to ensure children's rights were being safeguarded during the pandemic in Scotland. And it was thought that this change would bring in line with the UN Convention on the Rights of the Child.
Yes.
Was that the key driver, the concern from organisations such as the UN, which led to the increase of age from 16 to 18?
I think there certainly was messaging from the UN, but actually the primary driver in Scotland, and I should have meant they'll be upset with me for not mentioning them, the Scottish Children's Commissioner, or the Commissioner for Children and Young People, was quite vocal in the discussion around 16, 17-year-olds. It was having 16, 17-year-olds in the legislation fell out of kilter with the prevailing direction of sanctions for children and young people. We've seen a big change in the way that we deal with children and young people who are involved in offending in Scotland. We have a new whole systems approach. We have a new bill that's been trying to keep 16, 17-year-olds out of the criminal justice system. And the Scottish Government is heavily committed to the UN Convention on the Rights of the Child. So when the legislation was passed and when our advisory group was established, the Scottish Children's Commissioner was quite vocal about the fact that this felt out of kilter with the way that we usually did things. And I think looking at the freedom of information documentation that you mentioned earlier, I'm struck by the fact that no equalities impact assessment was conducted by the Scottish Government on that specific issue. I think Joe Griffin, who's already given evidence to the inquiry, has spoken to the fact that there wasn't time to do proper equalities impacts assessments of the legislation as it came in at the start of the pandemic. And that's certainly true. I think in my evidence I produced 2 documents of equalities impact assessment that haven't looked specifically at enforcement. But as far as I'm aware, enforcement hasn't been covered in any subsequent equalities impact assessments. If it had been at the time, I think the 16, 17-year-old point would have been picked up and that wouldn't have been allowed to go through.
And I think you say in your statement that that there's data which shows that there was 256 fixed penalty notices that were issued to people under the age of 18 prior to the introduction or the amendment to Regulation 9.
Yes.
And I think you also say that data also shows that there was a further 220 fixed penalty notices issued to people under the age of 18 after the amended Regulation 9. Why would that be?
I don't know for sure, but I think it's probably, I mentioned earlier, the confusion between having one type of fixed penalty notice that can be issued to 16 and 17-year-olds and one that can't. So it may well be that police officers were unaware or had forgotten that the change in the law had been made. If they had already been used to issuing fixed penalty notices to 16, 17-year-olds, it may just have been an oversight during operational practice. I think the other issue is that it's not always clear at the time when an officer is dealing with a person actually what their age is. So it could well be that it was just that they weren't aware at the time they were 16 or 17. I think it's highly likely, I think it's almost certain that any fixed penalty that was issued to a 16, 17-year-old after the legislation had been changed would have been rescinded.
I wanted to ask you about equality impact assessments.
Mm-hmm.
In your statement, you say that there's no available evidence to suggest that the Scottish lawmakers gave consideration to equality issues in respect of the decision to use fixed penalties. In Scotland, equality impact assessments published for the Coronavirus Scotland Bill and the Health Protection Coronavirus Regulations 2020 made no reference to the new policing powers or police use of enforcement, nor can we find evidence that retrospective equality impact assessments considered this issue. Had there been equality impact assessments at the time, what sorts of issues would those have identified?
I think I've mentioned the 16, 17-year-olds, they would almost certainly have picked that up. The other issue I would have expected them to have picked up is that in a quirk of the coronavirus regulations, they introduced an incremental fining system. Now, I mentioned earlier that Mr. Malthouse had stated that, introducing COVID fixed penalties was, a known science, that people were familiar with them, that they understood them, that they were easily accepted. And he gave examples of things like littering and dog fouling. What he didn't mention was that under the new incremental fining system, issued through the regulations that if an individual committed a second offence under the coronavirus regulations, their fine would double. If they committed a third, it would double again, and so on, up to a maximum of 5 offences, which would result in a fine of £960. So that is not the kind of light touch, kind of low-level fixed penalty that the public are used to in Scotland or the wider UK. So I would have expected an impact assessment to have picked up on that. You have to also bear in mind at this point there was very little parliamentary scrutiny of regulations. Things were happening so quickly. What we did have in Scotland was the Lord Advocate intervened. So when it was observed that there could be a potential for police officers, and remember a fixed penalty is an on-the-spot fine issued, you know, in terms of the discretion of the officer, officers dealing with new regulations, very unfamiliar with them, sometimes making, you know, good faith mistakes. If officers were issuing fines of up to £960, that would have been out of alignment with the level of fine that could be issued with the Procurator Fiscal in Scotland, which at that time was a maximum fine of £300. So the Lord Advocate issued guidance to say that police officers in Scotland could only issue a fine of up to £480, so that's a maximum of 4 fixed penalty notices. And at the same time, legislation went through, I think on the 7th of April 2020, which increased the size of a fine that the Procurator Fiscal could issue as a fiscal fine from £300 to £500. So that brought the police and the Procurator Fiscal powers in terms of their use of fixed penalties into alignment at that point.
I now want to turn to the data that we've discussed kind of in a very high level, and I want to look at the report that you produced. This is the report from the Scottish Centre of Administrative Data Research titled Police Use of COVID-19 Fixed Penalty Notices, and it's at INQ 000369770. So is this a report that you produced for the Independent Advisory Group?
This one, August 22. So the Independent Advisory Group by this time had been disbanded in May of that year. But I continued to work on the data that I had been using as part of the Independent Advisory Group. It was shared with members of the advisory group, and we did have a meeting with some of those members to discuss it.
And we can see perhaps at the top left of the top page, it says Policing the Pandemic in Scotland. So this is with your follow-up project after the work of the Independent Advisory Group.
Yes, that's right.
And I think this report analyses over 20,000 fixed penalty notices that were issued by the police to enforce non-compliance with public health restrictions introduced during the pandemic. And I think the data set is between March 2020 and May 2021. Is that correct?
That's right, yes.
Can we look at page 16, figure 3, please? And if we can look at, thank you. You'll see that this breaks down the number of police interventions in Scotland between May 2020 and May 2021 by reference to the 4 E's. Are you able to explain the different stages of escalation? First of all, are you able to explain the 4E strategy and then the different stages of escalation?
Yes, of course. The 4E strategy was introduced very early in the pandemic, in kind of late March, early April 2020 by the College of Policing and the National Police Chiefs Council, and it was intended as an easy-to-remember strategy that would minimise any potential negative consequences or impact of the introduction of the new police powers. I think there was a genuine desire by policing organisations to ensure that any impact that policing might have in the context of the pandemic would be as minimal as possible, on the basis that there was an understanding there might be wider inequalities. So the 4E strategy requested that if an officer was to encounter someone that may be breaching the coronavirus regulations, they were to engage with them first and talk to them, find out a little bit about what was happening. If it was clear that the individual was not following the regulations, the officer was to explain, or wasn't aware of what the regulations were. Then they were to explain what the regulation was to the individual. If the individual was potentially doing something that was in breach of the regulations, the police were to encourage them to stop doing that and make sure they didn't do that again. And only in the case of individuals who were flagrantly or deliberately or persistently breaking the regulations were they to move to enforcement. So that was the 4Es strategy. And the data that you can see there was extracted from the coronavirus intervention system that I mentioned earlier that was constructed by Police Scotland as a way of measuring encounters. And it takes every encounter that was entered onto the system by police officers and it broadly maps onto those 4Es. They use slightly different words in the system, but informing people was essentially the kind of engagement and explanation, and then instructing and removing them was essentially the kind of encouragement part.
Can you talk us through what the data shows in terms of the escalation to enforcement?
Yes. So the data essentially shows that in the vast majority of cases where the police had encountered someone under the potential for a breach of the coronavirus, in the vast majority of cases, they relied only on the first 3Es. So they didn't move to any kind of formal intervention. In around 11.6% of cases, they reported issuing a fixed penalty notice, and in 0.7% of encounters, they noted that an arrest had taken place. So that's around just over 12% of all recorded encounters involved enforcement. So that led us to be confident that the police in Scotland were following the 4Es strategy. It's not possible to compare it with any other police force because no one else measured it, but I think it was a really valuable tool that was introduced by Police Scotland.
So it's 1 in 8
Yes.
roughly interventions or encounters that led to enforcement.
Yes, that's 1 in 8 recorded encounters. I suspect there was probably a lot of other informal stuff that was never really recorded. So I would say that that was a conservative estimate.
And I think what this shows is even where there was enforcement, the vast majority of incidents only involved the issue of a fixed penalty notice.
That's correct.
And only a very small minority of cases required escalation to arrest.
Yes.
Can we then turn to page 25 and figure 11? And I'm looking at figure 11 at the bottom of the page. Now it's on the screen. Are you able to talk us through your findings as shown in this figure?
Yes. So this was an analysis of the fixed penalty notices that had been issued, and we were interested to see what the ethnic profile of individuals who'd been fined was. On the left, you can see the total absolute number of fixed penalty notices that were issued to individuals from different ethnic backgrounds, and you can see by far the vast majority were issued to people from a white background, which includes white minorities, including people from Gypsy traveller backgrounds is one of the main ones in Scotland, and that a kind of high level that maps onto the Scottish population, which is predominantly white. However, in order to determine whether there might be any potential disproportionality, you have to take the population figures and then calculate a rate per head of population for enforcement. So that's what you can see on the right. It's the estimate. We've called it the estimated rate because we use the most up-to-date population data, but there's always some level of uncertainty around population numbers that can change. So the estimated rate per 10,000 individuals within each of these ethnic categories. So you can see that actually when you look at population size, that individuals from Black, African or Caribbean backgrounds had the highest rate overall, and people from white backgrounds had the lowest rate per head of population.
I think overall, does this show that people from ethnic minority backgrounds were 1.4 times more likely to receive a fixed penalty notice than those from a white group during the pandemic.
That was correct, yes.
And I think that figure rises to 1.8 times more likely for somebody from an African, Black or Caribbean background by reference to the white population.
Yes, that's right.
Are these differences explained by differences in, for instance, compliance rates with public health restrictions amongst different ethnic groups, or do these figures show that there was disproportionate policing of people from Black and minority ethnic backgrounds?
We've been very careful in the reports that we've published to say that the analysis that we've done cannot be used to determine whether there was disproportionate or bias in actual policing. So in order to know whether there was bias in policing, you would need to know the level of compliance within each of these groups. You would need to know how many of those individuals had been encountered by the police, and then you need to know how many of them they find. We simply don't have that information. So it's impossible to say that there was any disproportionality in terms of the way in which the police were approaching.
Can you just pause there, please?
Yes.
Mr. Tarek, this is a really important topic. I'm just not sure it's one within my terms of reference.
Yes, I was going to move on, my lady, that I'm perhaps just following up on an interesting topic that's...
It is an extremely important and obviously an interesting topic, and I do understand that the Professor can give us a great deal of help. I just think we're straying.
Yes. I wanted to move to some of the policing challenges during the pandemic, and these stem from Scottish Government regulations. Perhaps if it's possible to take the report off screen. In your statement, I think you state that in research interviews conducted with frontline police officers, they identified with difficulties with keeping up with frequent changes in the regulations that were being enacted by the Scottish Government. And some of these were made very much at the last minute. Are you able to provide specific examples of difficulties that this presented in terms of policing the pandemic?
Yes, indeed. And I think it is important to say that this wasn't unique to Scotland. In fact, Tom Hickman has produced a lovely paper called Abracadabra Lawmaking, where he describes producing regulations like pulling rabbits out of a magician's hat. So it wasn't unique to Scotland. It caused problems for policing mostly at an operational level. So when we were working with the IAG, it was a frustration of senior officers that the speed and frequency of the regulations was coming through without... I mean, it wasn't that the Police Scotland weren't consulted at all through the process, but things were happening so quickly, and quite often they weren't consulted until quite late on in the process, that the level of input that they could have to that was relatively small.
Well, I heard in Module in London that sometimes they got a matter of hours' notice before the regulations changed. Was that the same here?
There was at least one occasion I can remember that the regulations had been enacted before the police even saw them. So, and actually there's no notice at all. And there's one really great example in the Holyrood Justice Subcommittee meeting, where the Chief Constable is being interviewed by the convener of the Justice Committee, and happens during the meeting to have something passed to them to say that there's new legislation coming in around introducing new police powers of entry, so that the police can go into properties where parties are happening. And the convener puts this to the Chief Constable in terms of the level of, the detail, and the Chief Constable, I think in quite uncomfortable terms, states that although he's aware of it and has seen drafts, he didn't know what was in the final version. So yes, it was a frustration of senior officers that they didn't always have sight of things. From an operational point of view, it causes problems when you've got a police force with over 17,000 officers, and you have to roll out training and instruction to frontline officers who are then going to go out and implement these new regulations. Now, I have to say that certainly in Scotland, Police Scotland took a very pragmatic approach to changes in the regulations, and they never wavered from emphasising the 4 E's approach and trying to minimise potential impact of any new regulations. But when we interviewed frontline police officers, they talked about, you know, the difficulties of going on annual leave for 2 days and coming back to a completely new set of regulations, and they didn't understand what they were doing. We talked to supervisory officers who said their staff were coming to them for advice on specific incidents and issues, and they didn't know how to advise them. Frontline officers also talked about trying to find, information was being dripped down internally within the organisation, although it wasn't anything like the kind of training that officers would normally receive. Normally they'd have months, if not years, of preparation. And they didn't have anything like that. So they were going to Scottish Government websites to try and find out the information. But the Scottish Government website itself was blurring the difference between what was regulation and what was guidelines. So that didn't always help either. So, yeah, there were a lot of operational difficulties.
I think you say in your statement, and I think you've touched upon this earlier in your evidence as well, that the distinction between law and guidance was often not clear, not just to decision makers or the media, but also police officers. Is that based on the information you were given in research interviews and indeed your work on the Independent Advisory Group?
Yes. What police officers said was that during the first lockdown, when the instruction was really clear, stay at home, then it was easy to operationalise the regulations. I mean, that's not to say there weren't some issues, particularly at the very beginning, before the 4E strategy really kicked in. But it was clear to the public what they were supposed to do. It was clear to the police what they were enforcing. As time went on and things started to be, ease up, and new regulations are brought in that provided for different circumstances or an increasing range of reasonable excuses, or when they were introducing things like when they were talking about, there's a good example I want to give you of the First Minister talking about the exercising once a day. Now, there was a lot of discussion about exercising once a day, not just by Scottish ministers. It was only ever a law in Wales. It was never a law here. It was guidance. And when Nicola Sturgeon if I get my dates, in May 2020, on the 11th of May, she said at one of her daily briefings, the only change we've made here in Scotland is to the guidance on exercise. As of today, we have removed a once-a-day limit on exercise. It is one very minor change to the existing rules. So in her own statement, she conflates guidance and rules. And of course, taking their cue from her statement, it was widely reported in the media that the rule of one exercise a day, exercising once a day, had been relaxed. Now, it might not sound like a very big thing, but to those individuals who were trying to follow the rules to the letter, and who really stuck to things and were careful, seeing someone going out for a walk twice a day and thinking that was a rule and not guidance would have caused some problems within communities. We know that a lot of the calls that came into Police Scotland around people breaching the regulations were neighbours looking over the fence or the garden wall and cliping on their other neighbours. So it did make a difference that there should be clarity between what is rule and what is guidance.
And operationally, this would have, if the First Minister is using language that blurs between guidance and rules, that operationally must present challenges to the police when they're trying to work out where they can enforce and where they can't.
Yes. We weren't able to get access to data on the reasons that fixed penalty notices were rescinded. So rescinded is when the police withdraw the ticket and it's not pursued. But we are aware from discussions through the Independent Advisory Group that a lot of the reasons for rescinding were where an officer had in good faith issued a fixed penalty notice for something that was guidance and not rule. In your statement, you say that during meetings of the Independent Advisory Group,
there were discussions with Police Scotland about new regulations that were considered very difficult to enforce. And you provide the example of regulations around quarantine restrictions on return from overseas travel as being something that was difficult operationally for the police to enforce. Can you explain what you were told about this issue in the Independent Advisory Group?
Yes, so in the Independent Advisory Group, one of the reports that we would receive on a regular basis was an update on some of the issues that were facing Police Scotland. They would quite often tell us about difficult cases, and they gave us a running report on issues relating to certain types of fixed penalty, one being travel and another being quarantine. And the difficulty that they faced with the quarantine regulations was that, so the quarantine regulations were really managed by Public Health Scotland. And if they could be dealt with satisfactorily through Public Health Scotland, then there was no recourse to the police. I think it was really only in cases where Public Health Scotland had tried to contact someone and hadn't been able to do that, that it was passed on to the police. Now, the police in these meetings told us that quite often the information that they were passed was incorrect. You know, phone numbers that didn't work, addresses that either didn't exist or the person wasn't there. But actually a bigger problem was that by the time Public Health Scotland passed the data on to the police to deal with, the period of the quarantine had elapsed. So there was really no point in the police taking up valuable resource to follow it up in any case.
You also say in your statement that travel restrictions, you'll recall the Scottish Government introduced in late December 2020, which banned travel between Scotland and England. That was another example, I think, you provided where it wasn't practical to enforce. Was that an issue that arose in the Independent Advisory Group?
Yes, and it was discussed both in the Independent Advisory Group and John Scott and myself presented to the Holyrood Subcommittee on Justice, and it was discussed there too. Essentially, this was a ban on travel, cross-border travel between Scotland and England that was introduced on Boxing Day in 2020. And the specific concern was about the spread of a new variant in England, which hadn't really reached Scotland at that point. And I think the idea was we have a travel ban so that people don't bring this nasty new variant here. Although they also made changes to the local levels at that point, so it was actually quite a complex regulatory shift. So the First Minister announced this at the daily briefing on the 19th of December 2020 and stated that this travel ban would come in and they would be asking Police Scotland and transport operators to consider how the enforcement of this can be strengthened in the period ahead. So the insinuation is there's going to be pretty heavy enforcement of people crossing the border. Now, this is another example of where there's a tension between what the government wants to articulate through its messaging, and I can fully understand the intention in terms of trying to make people understand the seriousness of what this might do, but tension between that and the practicalities of policing. So almost immediately, Alan Spears, Assistant Chief Constable at the time, released a statement from Police Scotland to say that they would be continuing to focus on the 4 E's, that they were encouraging people to take personal responsibility, and they would not be routinely stopping vehicles or setting up roadblocks. On the day that the law came in, the Chief Constable reiterated that again, saying that the restrictions were preventative, and they did double the police presence on the border, but they made it very clear they would not be proactively stopping vehicles. And when John Scott presented to the Holyrood Justice Subcommittee, he described it as a restriction that was simply impossible to enforce. It's an example of something that's unworkable, and he gave an example of roadblocks that had been used, set up in Melbourne in Australia, which had caused absolute chaos and had not had the desired effect. So, so that was another example of something where a bit more communication between government and the police might have led to more harmonious press releases.
And I just want to move on to lessons learnt. I'm nearing the end of...
Just before we do, before you go to lessons learned, Mr. Chair, can I ask this? I heard in England about the drafting of some of these regulations, and the drafting went to the Department of Health in England, whereas normally it would be the Home Office responsible for drafting criminal justice regulations. And I suspect partly as a result, I had a look at some of the offences. I've got a background in criminal law, so and they were nonsensical. I mean, they wouldn't have made sense to, I suspect, a criminal law professor, let alone the poor police officer or alleged offender. What were the regulations like here? Were they better drafted?
Well, I've not done a big study of
Right, were they
comparing
well
the
drafted
regulations.
then? Don't do the
But there
comparison.
are examples of some of the regulations where it was absolute gobbledygook. There's one classic example of an explanation in a policy memorandum, which is trying to explain, it's the rule of 6, and it's trying to explain how many adults can meet and how many children there can be and what the ages of the children can be. And it's about 2 or 3 sentences long, and it is absolutely impossible to fathom. And again, this kind of speaks to another issue of very fastly drafted legislation. I can see the intention was to try and be clear about, in this circumstance, based on our legislation, you can have these people. But it was impossible for people to understand. And you can see why police officers and members of the public would have been very confused about whether they were committing an offence or
And
not.
who did the drafting?
That
Yeah.
I do not know, because I wasn't involved.
Maybe
in the
we can
Scottish
find out some
Government.
other way.
Yes.
Thank you.
It's an area we can explore with subsequent witnesses, my lady. I now wanted to just turn on to lessons learned. In a future pandemics situation, is there a more proportionate response than using sanctions to enforce public health restrictions, in your opinion?
Well, if you want to include a sanction, the only level down from a fixed penalty notice, which is reasonably proportionate if you keep them at a low level that the public expect. There's an inherent inequality in financial penalties. A fine of £60, which is the minimum, a fine of £60 for a government minister might be a small amount of pocket change, but that might be quite a large amount of money for someone who's experiencing financial hardship. And remember that the person that commits the offence doesn't need to pay the fines. So there are individuals who did have fines paid for by other people, including a number of well-heeled students. And that inequality is offset by the fact that these sorts of on-the-spot fines are relatively pretty small. But when you start to ratchet up the fines to hundreds of pounds, that's not a small fine anymore, and that inherent inequality is quite large. So, sorry, I've forgotten the original question, but
What's the proportionate response?
a proportionate response. I mean, if you kept the fines low level, you continued with the 12 E's. I'm sure we could find a few more. The 4 E's approach, and you improved lots of other things like more consistent, clear legislation that was distinct from guidance and focused on supporting people to follow the rules rather than punishing them for not following the rules. Then if you were to move away from a fixed penalty, then a formal warning would be the next level down. I think you have to remember that laws are there for the most part, to deter the law-abiding majority. And in the context of the pandemic, most people were the law-abiding majority. We've talked about enforcement today, but in Scotland, less than 0.5% of the population were subject to enforcement. So in the grand scheme of other inequalities and impacts the pandemic had, enforcement might seem quite a small thing, but it did impact on thousands of people, and it impacted disproportionately on people from more deprived backgrounds and individuals from certain social groups. So I think it's always important to try and minimise the effect of any sanctions in the context of a public health emergency, where there are lots of other inequalities that are going to be impacting on these individuals. And very often the inequalities intersect. So the people who were subject to repeat fining, for example, were highly likely to be people who were also impacted in terms of health and economics, potentially education as well.
My lady, there's no further questions from me, and I understand there's no live Rule 10s.
Thank you very much indeed, Professor McVeigh. Very grateful. As you say, there are many people where the impact was dreadful, but one of the lessons to be learned is that when you impose what are essentially criminal sanctions, even if you don't end up with a criminal record, you've got to make sure you get it clear and right. And maybe if we're being better prepared, all of us, before, we might have had some draft bills or offences that we could have implemented. Who knows? But thank you for your help.
You're very welcome. Thank you.
I think it's 10 o'clock tomorrow. For those who were interested in seeing the evidence of Alistair Jack MP, for reasons that are not his fault, they're not the inquiry's fault, I'm afraid we can't call him tomorrow, I understand. So we'll start with Elizabeth Lloyd. But we hope to call Mr. Jack next week.
Thank you.